Good afternoon from South Africa and welcome to another one of our SADAR webinars, especially in this time of interesting crises and crises. As we unpack today, we're going to be talking about something slightly different from the last few weeks where we've been unpacking responses to the pandemic that we're all going through. And we're going to be addressing something else that has come up in numerous contexts. I'm based in South Africa. It's one of the reasons I'm wearing a scarf, because we're in the middle of winter. And we have seen over the last few weeks, and especially the last 2 weeks, a number of cases taken to the next level against directors, against decision makers in business, both in public sector and private sector. And I think one of the questions we get asked very, very often is, well, how can directors who are now starting to see these concepts like director delinquency, delinquency of directors, probation of directors, what does it actually mean and what can we do about it? And I want to unpack some of those concepts for you over the next 45 minutes or an hour. Thank you for joining us. Thanks again for investing the time and attention. And as we go through this webinar, please engage. As I've mentioned at the bottom there, you can either use the chat box. I do have the chat box open in front of me. I do have the Q&A open in front of me. And as you go through, please let us know what you're thinking. We've obviously seen some high-profile cases in South Africa at the moment, and the current status is that it is being appealed. So that's the current status. But the ex-chair of the South African Airways board was found delinquent for life, which is an interesting phrase that we're going to unpack a little bit of today. The case has been around for a long time. Those of you who are in South Africa would know the case of South African Airways. For the others of you, South African Airways, our flagship airways, has been in trouble for many, many years, has been the subject of many, many news broadcasts, has also been the recipient of billions of rands of bailouts over the years. And the focus has been on the role of the board and the role of the chair and the role of the directors in that context, along with many of our other, not just public sector entities, but private sector entities. We've seen collapses like the Steinhoff case a few years ago. We're seeing ongoingly series of both public sector and private sector crises, and many of those are putting the focus on the boardroom. And as the legal process is being followed, we are seeing many of those cases, and they're high-profile cases. They're not the first cases of director delinquency or director action taken against directors, but they are certainly some of the most high-profile. And so they're leading to many people asking this question: what does it actually mean to be known or found as a delinquent director? And so one of my disclaimers, I suppose, is that this isn't a webinar with legal advice. What I want to do is unpack what the concept of delinquency means, and more, what can we do to remedy it? What can we do to fix it? What can we do to hopefully prevent it from happening to us? And I think this quote by John Maxwell sums up the thinking: a leader knows the way, goes the way, and shows the way. And I think the key thing is, and a board is a team of leaders, and they need to work together. They need to act together to protect the best interests of this thing called a company that they are accountable for. And so I want to unpack some of those elements as we go. And so I'm going to start by thinking about, what does this word delinquency mean? And it's an interesting word because it's a word that we normally use in the criminal context or in the misdemeanor context. It's an interesting one to be found delinquent as a director. And I think that's what makes it such an interesting word. And so the way that I work is I often go through and I say, well, what does this word actually, where does it come from? What does it mean? And then how do we relate that to this position or this person of a director? And so the three parts of today, we're going to look at that. What does it mean, this word? What does it mean in terms of position and role of directors? Because I think that's the critical thing to understand, is it's not out of context. We've got to contextualize it in terms of the role and the position of directors. And then we've got to ask the question, what are some steps we can take to ensure that it doesn't happen to us? Or if we are acting in certain ways, we can prevent it going any further, possibly on our boards. And so there's a bit of self-diagnosis as well as we go through this webinar. Interesting when we look at the word delinquency. Delinquency has to do with the concepts listed here, that it's about a failure of duty, which means if we need to understand failure, we need to first understand duty. And so we'll look at that. It's an abuse, a neglect, or dereliction of duty. And so the picture that I have, and the picture that is in this word of, either taking a position and using that position for the wrong purpose. And so it's important to understand, well, what is the purpose of directorship? What is the purpose of this role of directors? Because that's the context. Neglect. And I think one of the things we see regularly is we drive around and we see buildings that have been neglected. They're tatty, they aren't looked after. We see companies where we wonder how they got into the state they were in, and there's a neglect of this duty towards another, and we'll unpack that. And then this concept of dereliction, and dereliction is an interesting word because this is the one I needed to look up and understand and think about and work through, is really think, what does the word dereliction actually mean at the end of the day? And dereliction in a sense is also related to a position or a post. So there's a concept when we're in dereliction of one's duty or post, is to abandon it. There's an abandoning of one's position or an abandoning of one's duty. I just see a hand that's gone up. If you wouldn't mind putting your comment or thought into the chat box, and then I'm happy to address it or ask a question in the question box going forward. And so one of the key things as well is there must be intention or what's called gross negligence. In other words, director delinquency isn't something that isn't serious. And I think there is a seriousness that is necessary for this finding to ever be made. It's not about, something that happens in the course of events. It's not about, a mistake or an accident. There needs to be a serious, either series of events. In other words, a failing in one duty. And these words are very strong words: failure, abuse, neglect, dereliction, negligence. These are very, very important, strong words that we need to unpack when we think about director delinquency. It's also important to understand what the consequence of being found delinquent as a director. And there's a disqualification, and again, another very strong word that I think is really important. And I'm emphasizing these strong, definitive words, because this isn't something that is random. It's something that is a strong action against a director. The disqualification can be conditional, can be made conditional on certain things. It can also be made for a specific time period, and different legislative frameworks would often have a minimum or a maximum time period. Although the maximum could also be for life, and that's why this finding was an interesting one, which, as I mentioned, is under appeal at the moment, was a delinquency for life. The time period in South Africa is 7 years, and then there is this process often of, and it's called rehabilitation, where there would be mentorship, a range of different, actions taken for someone then to become rehabilitated as a director. So there's a significant seriousness about this term delinquency or director's delinquency. And so if we want to understand what those mean, so neglect, abuse, negligence, we need to understand what the duty of directors are ultimately. What are their duties? How does the law see this role of directorship? Because unless we understand that, unless we understand the concept of what they should be there for, or what directorship is there for, then we can't understand fully the significance of being found delinquent or negligent in our positions or roles. And I think that's also one of the challenges. And so what has happened internationally is, as the company law, corporate law has changed, adapted, especially in the last 15 or 20 years. And so many countries throughout the world, and especially in Sudan, we work throughout Africa, many countries have had revised or new corporate legislation, company laws that have been rewritten. And one of the most significant things these pieces of legislation have done is they have clarified and put the focus on the role and position of the director, both individually and collectively. And so the director and the board are really the crux around which the law assumes a company operates. There are obviously other relationships in the company. There's the shareholder role, there's thinking about the ongoing management of the companies, but there's a significant weight put on the shoulders of directors. I often use the illustration, the director jacket is not a light one anymore. It's a heavy one. It has a heavy responsibility. It has a heavy, weight, because it is the party and the group of parties, the director individually and collectively, that the law is giving authority to, and so is also able to hold accountable. And so we need to understand what this position and role of directorship is. And for many of you, you've probably heard many of these words, but I do want you to take them, seriously. And as I said, as we go, please ask questions or make comments. Tell us what's on your mind in the chat box or the Q&A box. And so let's look firstly at the position of directors. And so directors are put by the law into this position which is known as a fiduciary position. And the undergirding words, and that's obviously a word that is quite a legally bound word, but it's a word that has underlying it the concepts of good faith, trust, or care. The word fiduciary comes from the Latin word fides, which means good faith. It's about a good faith position. It's a trusted position, but it's also a position of care. I often say that a fiduciary is often, we see it in a trustee context, we see it in a guardianship context. So someone is a guardian of someone else. So if someone's children are abandoned, a guardian is appointed to them that is expected to act with the same level of good faith and care towards that person, that party, than they are towards their own children. It's also a position that is created by law. And this is an important thing to understand, is that the illustration I often use is I say that the director's seat is created in the law, and then someone sits in that seat. When you sit in the director's seat, you're expected to do what the law requires. You're both authorized to do what the law allows as a director, but you're also expected to act in that position. And this is where the concept of dereliction of duty, or abandonment of one's position, neglect, leaving one's post, is an important one to understand. And so underlying it, there is this fiduciary position. And some characteristics of that fiduciary position is that, and this is where some of the terminology it's really important to understand. So in law, the party in law that is normally allowed to appoint the director is the shareholder. So there's a specific relationship that the shareholder has with a company, and we would call that an investment relationship. They are looking for a return, but their appointment of a director doesn't create a relationship between themselves and the director. This is really important to understand. The director is put in the seat that is already in a relationship with the company. And that relationship, as we said, is a fiduciary position and relationship. And so we often compare it and say, well, if I'm a shareholder and I'm asking someone to attend a shareholders meeting on my behalf, I would appoint them as my proxy. And what a proxy means, so as a shareholder, I can appoint a proxy. What a proxy means is that person is acting on my behalf. They are my voice in the room. That is not the same relationship that is created when a shareholder appoints a director, because the relationship between the director and the company is already established. It's a fiduciary relationship. And so often we get, and you'll see one of the dangers that can lead to delinquency is when a director, a group of directors, a chairperson acts not in the interest of the company they're a fiduciary of, but they're acting purely as a proxy for someone else. And so the concept of connectedness and relatedness is an important one that is, contextualizes these issues. Directors are also, so they're put in this relationship with the company as a fiduciary. They're also allowed to benefit from, but it's a requisite benefit. So directors are allowed to charge fees to the company. Companies are allowed to pay directors' fees. When it becomes an not requisite, an inappropriate benefit is where there's a challenge. And so there's an allowable exchange because it's a contract, it's a professional contract, fiduciary contract with the company. When this starts shifting into the delinquent director is when the director, the person who is the director, perceives their appointment as a proxy or representative of someone else. In other words, they don't see themselves in the boardroom, and these are some of the danger signs that we need to be thinking about. When I'm sitting as a director, I'm actually only allowed to keep one person in mind, and that is the person of the company. If I see myself as the representative or proxy of someone else, I'm speaking for someone else in the boardroom, then that's a dangerous position to be in. They see themselves as related to the appointee instead of related to the company itself. All right. And they often get or have access to unrelated benefits. So the benefits of directorship should be linked to the position of directorship. And as I said, that's a contractual relationship. Someone is appointed, they're contracted as a director of a company, they're appointed to that position. And when you're appointed into that position, you get given the authority for that position and that position alone, and you're expected to act in the benefit of the party for which the position is created, and that is the company. And so the role of directors flows out of that position. And the reason I'm emphasizing this is because remember we said delinquency is neglect of, it's dereliction of, it's abuse of. And so there's the position that is there, but then the role in that position is also spelt out in terms of the law. And the phrase that sums it up is really acting in the best interests of the company. And again, that comes from the fiduciary concept. It comes from that caring concept. And this is an interesting one because directors individually and together are legally obliged to play that role of acting in the best interests of the company. And so one of the challenges, and I acknowledge that it's often very difficult because we enter the room as directors with a range of interests in mind, from my own to other parties to other influences. And the mature director recognizes that, and the mature team recognizes that and holds themselves and one another accountable for this concept. And we'll see how the law actually is starting to provide mechanisms for us to focus on this element as our defense as directors as we go forward. And so what does this mean? And there are three key words that most legal frameworks boil down the fiduciary duty to. And the most important thing about these three words and the duties or the legal duties of directors is, and this is quite a powerful concept, is that the way they are expressed in law is less about a list of thou shalt nots. In other words, the law doesn't say to such an extent, directors shall not do this and not do that and not do the next thing. Rather, the director's duties are spelt out as expressed as a set of positive duties. And this is why, even though I emphasize the negative words up front, actually directorship is an incredibly positive. The law assumes a lot of things about how directors are going to act. And that assumption is housed in these three words: care, skill, and diligence. And I think they're three really powerful words, and they're words that we need to unpack. I remember once, speaking to a board, and I asked the question, and the response was, I've never been asked quite that question before. I asked the question, what does care look like in the boardroom? What does care look like in a policy framework? What does care look like in a resolution or a director's decision? And it's interesting because when we test what we're doing, we can ask ourselves, are we caring? Are we competent? The skills are the key one. And I think that's one of the big challenges in today's world, is that many directors, unfortunately, don't necessarily have the requisite skill set to be directors. And then diligence. So care is this word that is an interesting word in a legal or in a very technical space. Directorship is not often seen alongside the word care, and yet it's the first word used in directors' duties. There's another interesting, anecdote that Jack Ma, the Chinese billionaire, he uses a phrase which is also quite interesting. He says businesses shouldn't be run based on their IQ or even their EQ, intelligence or emotional, intelligence. But he says he thinks about his business in terms of LQ, the love quotient in his business. It's a bit conceptual and a bit out there, but it's really starting to put the pressure on. How do we actually see our role as directors? Are we acting with due care towards the company that we're a director of? Obviously, skill is an important thing to think about. And one of the challenges around skill in directorship is that it often looks the same as skill in management. So directors would often have the same skill set to senior managers in a business. But one of the skills of directors is a different mindset towards the way you approach or apply that skill. And we often hear the phrases, it's a skill of the mind and not a skill of the hands. It's seeing and not doing. And that obviously is the primary difference, or one significant difference, between the governing approach and the managing approach. But it's often the perspective, it's the way we use the skills. And often what happens is in a boardroom, or directors need to re-look at the toolbox they have as that they've learned through their experience in their operations, and use those tools, those skills and that experience in a slightly different way. It's about seeing the whole of the company and not working on the company and not just working in the company. Different approach. And then diligence. Diligence, the word I like to use there is consistency. So as directors, are we being diligent on an ongoing basis? Are we being consistent in our approach? It's no good doing 3 months of great work as a director and then 9 months of lack of preparation, ignoring what's happening in the company. Actually, there is a consistent long-term approach to directorship. Directorship is a bit like the marathon. It's not a sprint. It's a long-term. The cycle of directorship is a slower cycle than the cycle of management, because the management cycle is daily, weekly, monthly, quarterly. Directorship is every second month, every third month. It's the quarterly and the 6 monthly and the annually and the 3 to 5 year picture that we hold in mind at all times as the best interests of the company. And so we need to examine ourselves. And if we look at the delinquent director related to that, so the words I've used are kind of dereliction versus care. And dereliction is when we abandon our post, when we leave something alone. We refer to derelict buildings, and we'll drive through neighborhoods and we'll say it's derelict. Nobody wants to be there, and yet that's often what happens around our boardroom table, is that if someone is derelict, they're not present. And remember, it's not just a physical presence, it's an emotional, it's a cognitive, it's a engaged presence. And so a delinquent director would start off by being derelict in their duties. They don't properly prepare. They leave the decisions up to somebody else. They just go with the flow, potentially. And I'm not saying that's the definition of delinquency, but it could start there. And so each one of us as directors have to look at ourselves and saying, which parts of my role am I derelict in? Where am I abandoning my post and not stepping up and engaging? And this pandemic has been a really interesting case study in I've seen people re-engage with their positions in their posts as directors and realizing that this is on my shoulders. This is on me, on us as a board. Incompetence versus skill. And one of the most devastating effects of political appointments, and that again, I'm using that in both the public sector where we see that happen often, but also political appointments in the private sector, being part of the old boys network. And unfortunately it is the old boys network often. Just being chosen as a director because, well, we know you and you seem to have done all right. So there's a political element in the decision making. Instead of asking the question, what does this person actually bring to the table? Do they have the skills at directorship level? Do they have the governing skills necessary? And then negligence, sorry, it's negligence versus diligence is what that slide should say. And I think this is the important thing, is so if I defined diligence as consistency, then negligence is inconsistency. And so each one of us needs to look at ourselves in the mirror and saying, to what extent have I abandoned my post as a director? To what extent am I incompetent, or do I not have the requisite skill set? And remember, we can always learn. And then to what extent am I neglecting? Am I inconsistent in my approach? Do I run this race in fits and starts as opposed to just pace myself? And so if we look at the legal duties of directors, before we switch to saying how do we remedy some of this, one of the most important things as well about the thinking in law around liability is that liability is shifting from just the title of director to the role of decision making. And you'll see why that's important when we look at how do we defend ourselves, or what are the remedies for delinquency. And that's why I put in brackets there, if you notice, the word prescribed officers, whether that's a phrase, or there's the company officers is another phrase that is used. But essentially there are these two key duties, as I've mentioned. There's this fiduciary relationship and duty, which is summarized by the words care, skill, and diligence. And there's an underlying assumption, as I said, that is a positive assumption. So even though we see the negative news flow and the negative findings against directors, actually, the reason they're so serious is because the law assumes the best. And we'll see that when we talk about our defense, the remedies that we have available. And the point of departure in the law is there is that relationship is one as utmost good faith towards the company. And if there's utmost good faith, then there is a necessity to act, to apply one's skill and care in performing one's duties as a director. And so that's the basis for finding someone delinquent, is because it is such a serious break or breach of what is assumed in the legislation. And it's a breaking of the legal framework in a sense. I know that's maybe a bit of an extreme way to think about it, but that's critical to think about. And so what do we then do? And I think this is where I'd love as well to get some thoughts and questions. And we're often asked the question, and these are coming up, is then, what do we actually do about it? And part of me looks at the legal cases that are unfolding, and there have been a few, and there will be many more, and there are lots in the pipeline. And the metaphor that I could only think about, and obviously it's because we're going through this crisis, is that delinquency is something you do not want to get. It's something you want to prevent happening. And we're going through this pandemic, and we don't want to get the pandemic. So we put masks on, we put shields on, we wash our hands, and we do all kinds of things. That ultimately, delinquency is something we should avoid, because fixing it's often too late. And this is where we see some of the cases where we have companies, and I think what we've seen, I don't think I know what we've seen, is companies now are starting to say they're starting to use the pandemic as an excuse for something that was already broken. And so it's triggering a collapse, but actually many of those companies were already ill. They were already sick. They were already had a virus, the virus of delinquency. And so that's probably, if I can't emphasize anything more, it's the fact that we don't want to get this thing called delinquency. We have to prevent it, because the remedies are not great at the end of the day. Fixing it is difficult. And so how do we think about preventing as opposed to just curing? And three key elements I want to unpack for you. Firstly, it's about recognizing that as a board, we are a group of leaders, a team of leaders. And so we need to exercise team leadership, which means there's no room in a boardroom for domineering, dominant personalities that override everybody else. It's about a team working together. Now, I'm not saying that there's no room for robustness and challenging one another, but there's a maturity that is required that says we're a team of leaders that are interdependent in our acting in the best interests of the company. We need to do this together as opposed to a group of individuals that often are highly skilled and highly competent, all right? But they are acting on their own interests as opposed to collectively in the best interest of the company. So I'll touch on a couple of ideas there. It's about a well-designed process, and you'll see that directors are often better protected. Well, the protection of directors lies in the process they follow, as long as it's a well-designed and well-implemented, diligently followed process, than in just ticking the box and going through the motions. And then it is about competence and knowledge and understanding how to apply the skill set and grow your skill set as directors. So if we start with team leadership, we have to think about how do we actually put the team together. And there are a couple of other webinars we've done on this, so you're welcome to get those via the CIDAR website on how to think about putting the team together. And so we do need to think through a number of different dimensions. And in the South African context, we have the King Codes, the King Code of Corporate Governance in South Africa. But one of the principles is one we can all apply and all think through. And it talks about the composition of the governing body or the board. And so the governing body should comprise the appropriate, and this is important, appropriate in terms of the company. We don't rattle off a list of requirements for a board unless we understand what the company actually needs. Remember, the team together must act in the best interests of the company. And so what happens is when you get people appointed for the wrong reasons, the inappropriate purpose or reason for being appointed, you often get those people domineering, pushing agendas that are not appropriate in the boardroom, and that can lead to drifting towards delinquency. The appropriate balance of knowledge, skills, experience, diversity, and independence. So there's a number of different elements, and as I said, we have unpacked this in other webinars, which you're welcome to take a look at. For it to discharge its governance role, both objectively and effectively. The position of the board, as I mentioned, is one that works on the company and not in the company. And so the objectivity and independence and effectiveness of the board is essential. In a sense, the board is looking at the whole company at almost arm's length. We often talk about that arm's length relationship so that they can see how the whole fits together and they can govern the whole as opposed to just a whole lot of individual parts. Remember that the law puts liability on this team of people that needs to work together. And so the team approach is absolutely essential. It's also thinking of how do we work together as a team. And this is where the role of the chairperson of a board becomes absolutely critical. We often think that the chairperson is a superior to the rest of the board, whereas actually they are a leader of equals. Their role in the boardroom is to facilitate the most robust, the most, the strongest, the most deep conversations, all in the best interests of the company. They're the ones who needs to draw out of each individual director the contribution that each individual director brings to the table. And that's a question. If you're sitting and chairing a board, you need to ask yourself, am I skilled? Because your skill set is about pulling those things out of the different directors so that the decision is robust and also follows an appropriate process. So working as a team, element 1. Thinking about process, element 2. And this is spelt out in many legal frameworks. It's called the business judgment test. It's something that has recently been brought into the South African context, but we can learn from it wherever we are, because the business judgment test is an interesting one. It's a way of saying, how do we create a set, so alongside these positive responsibilities or positive directives on directors, care, skill, and diligence, how do we provide an elegant defense mechanism that if they act in a certain way and can prove they've acted in a certain way, it's not jumping over through a whole lot of loops, but there's a few key elements of a process or elements that we can include in our process that enable us to defend ourselves as directors. And so the aim of this is to balance a couple of things. It's to balance the fact that we need to act. So directors are given authority in order to act, and their acting as directors is essentially deciding and holding accountable those who are implementing the decision. So making decisions and implementing decisions at its most basic level is all a company is really about. And then it's got to balance that with holding the decision makers and the doers accountable appropriately. And so this is its purpose, is to balance this need to act. It's also designed ultimately to promote a few things. It's designed to promote risk-taking. You see, if we just think of directors' duties as liability, we're going to avoid doing too much because we are scared of getting it wrong. Whereas actually, if we have a defense that runs alongside it, that says you need to go and act and you will be held accountable, but there's a way of ensuring that your accountability is properly, assessed, promoting risk-taking, which is absolutely necessary in business, and especially at this time, absolutely necessary. We are in incredibly uncertain times, and we need to be stepping forward. And the second thing is that it's encouraging competent people to serve as directors. See, competent people want to exercise their gifts and their skills and their experience in the boardroom. And the important thing about governing is we put the parameters in place so that that is appropriate and it's directed in a certain way. And the word director has that picture of directedness in it. And the third thing that the business judgment test wants to do is it essentially wants to avoid the law having to second guess you in the future when a decision you've made goes wrong, all right? Or potentially causes harm or is perceived as being negative, all right? Because what the business judgment test will look at is it'll say, well, you had a decision to make or a series of decisions to make. What did you do in making that decision? Because this is where defense by process becomes important. The law isn't necessarily interested in whether there was harm or caused or not. Now, I know that's maybe a blanket statement, but the first thing isn't the harm caused. The first thing is, how did you make a decision given what you had available to you, the knowledge you had, the access you had, the reporting you had? How did you make the decision? Because if you made a good decision based on what you had, that's defensible. And so it's spelt out as follows. There's 3 or 4 key elements of it. And the first key element is there must be a decision or a judgment. And I think one of the frustrating things in boardrooms often is we don't clarify what the actual decision is. There needs to be a conscious decision. It's either a decision to do or not to do, because both of those are decisions at the end of the day. It's not just failure to act. It also is not, it doesn't justify rubber stamping. Actually, it's expecting you to make the decision because the liability lies where the decision is made. And that's really, really critical. What I like to throw around is the word decide has within it. So the CID in decide, or the CIS in decision, is actually the Latin word for kill. And so what the law wants to do is it wants to make sure that you as the directors made the decision, because the liability already rests on your shoulders. And so that's what it's wanting to ensure, that you're not just rubber stamping decisions made elsewhere, because then you're potentially liable for decisions you didn't make. And so there's an expectation in the decision or judgment for you as directors to properly evaluate the various risks, impacts, consequences, everything related to the decision. You see, what neglect or dereliction of duty does is it says, I'm just going to do what I'm instructed to do. It says, I'm just going to throw up my hands and just let what happens, happens. I'm going to abandon my post. I'm not going to engage properly to understand the decisions, ensure that we're on the same page in terms of the decisions, and then ensure that I have the requisite amount of information necessary to properly process and make that decision. And that's why due process is important, so that you can show, how did you assess the risks? How did you look at the consequences? How did you look at other underlying assumptions? Did you test the assumptions? Did you ask the tough questions on those involved? I think one of the challenges we've seen in some companies that have appeared very successful and then collapsed is that the directors didn't ask the question, why are we so successful? Because if we are more successful than everybody else, it's either a secret sauce we have or someone is doing something wrong. And that's the kind of approach. Have we tested this thing from every single angle. And we can only do that if we've been clear about what the decision or judgment is actually all about. The second part of it is that we must know what we are doing. All right. And so there's this term or this string of phrases, knowingly, knows, and know. And the reason I highlight that is because what the legal frameworks are starting to do is to starting to say, well, what does that actually mean? And there's an underlying assumption in your position or in your role, or when you sit in your position as director. And it's this one. And this is a quote from the South African Companies Act, but it shows the direction of what we need to think about, is that knowingly knows, when used with regard to directors and officers. So when you're making a decision, it means that A, you had actual knowledge of the matter. So that's the dictionary definition. But B is the legal definition, which says you were in a position in which you reasonably ought to have had knowledge of the matter. And so one of the dangers of the older legal frameworks, which weren't as clear about these things, is people said, well, I was only a director. I didn't know what was going on. The law now assumes that when you sit in the seat of a director, you actually know what's going on. You have the knowledge, because you do have access. A director, because they're given all the authority, also has access to all the information in a company. It's not helpful that they get it all in one go, but if necessary, they need to explore. There's also an expectation on directors in that definition that if you didn't know, you asked the questions. So did you explore the matter? Did you take other measures? Did you investigate? Did you speak to other people? All right. Because if you can show, if you have done that, you need to be able to show that. And that's critical when we think about it. Your process of getting to know is an important thing to record. Your own explorations, the questions you asked, the challenges you made, the debates you had in the boardroom are critical. Now, not that we necessarily record every word, but we need to record enough so that we can substantially recreate the process that was followed in finding out. And so whether that's ensuring that you spread your decision-making over 2 or 3 board meetings so that you can find out in between and you can explore and you can investigate on your own between the meetings. Very dangerous to throw a decision into the board pack and make a decision on it without having an opportunity to ask questions and find out. You see, it's the process used to come to the decision and not necessarily the merits of the decision, which could be under investigation, because the law doesn't want to second guess you. It wants to look at how you made the decision and say a reasonable group of people with this level of information would probably or could plausibly have made the same decision you made. And in that case, we've satisfied the knowing element. The second element is obviously this concept of conflict of interest. And this is linked to other connectiveness and connectedness and relatedness. And so there's a whole lot of definitions and concepts in law about, and primarily it boils down to, as a director, you're expected to act with a single relationship in mind, and that's your fiduciary relationship in the best interest of the company. Any other relationship you have that is part of a decision is assumed to throw you off the mark. And so the law is, in a sense, it's expecting you to know, it's assuming you know, and it's also requiring you to disclose any other relationships. Because there's an assumption in law and underlying legal frameworks is this concept of being and being seen to be. And so we can technically say, well, that didn't influence my decision-making. The problem is those other relationships often are seen to be influencing one's decision-making process. And so there's an expectation, there's a requirement in law for a declaration of the conflict and a recusal. And then minute it. Make sure that you minute that you were not in the room when the decision was made, because that could be your defense. And then in your asking of a conflict of interest, don't ask the question when you make a decision in such a way that it is a definitive yes or no question. It's not a maybe. You can't have maybes in conflict of interest. You either are or are not. And it's important to think through what that means in your company. And then the third element, which is really the critical element, is that there is a rational basis for believing that the decision was made in good faith in the best interests of the company. And I think what we lack sometimes in our decision-making processes is that question. So we ask, is it a good question? Is it a good decision? We ask, have we got enough information? We ask, is the information complete? We ask, is the information accurate? But often in our decision-making process, we don't ask, how is this decision in the best interest of the company? In other words, what do we expect it to achieve? What do we expect it to result in? And asking that question, obviously after we've known what we're doing, after we've declared any conflict of interest and left the room, is we then come back and say, well, actually, let's quantify this. Let's put it down. Let's think about, how this decision is expected to benefit the company. And I think that we need to ask that question in our strategic processes as well. We need to think about the strategy, because ultimately defining strategy of the business properly is defining what we believe is the best interest of the company. The best outcome for the company should be the strategic objective, which would then align our decision-making to the best interest of the company anyway. I see there's one question. Thanks, Jenny. How far does the conflict of interest go? So relating to that second element. So in a sense, there are three hurdles. There's the knowledge hurdle, there's the conflict of interest hurdle, and then there's the best interest of company hurdle. And we've got to get over all of those as our defense. And we can build those into our processes. The question about how far does conflict of interest go? So again, it's defined slightly differently in different spaces, but in the South African Companies Act, it's defined as 2 levels of relationship. Now, the word used is an interesting one. It's 2 levels of consanguinity, which includes all natural adopted relationships, but also includes very, very close relationships. And again, it's being and being seen to be. It also includes, and this is it's not only personal relationships, another aspect of it is also the company relationships. So relatedness through shareholding, through subsidiaries, all of those kind of things that we need to balance and declare. And so those 3 things are absolutely critical when we're thinking about our decision-making process. Have we built into our process the knowing phase of our decision-making? Do we allow time for people to explore and investigate? Because if we jump over that, we could be seen as neglecting a duty, as being in dereliction of a duty, as being abusing a duty by just bulldozing decisions through a board. Second, thinking about, have we put in our decision-making process and in each declaration of interest, conflict of interest? Are there any other things that you're concerned about in this decision? Any other relationships that you have related to this decision? And then how have we qualified the best interests of the company? And that's important to think about. And then the third element. So we've spoken about the team, we've spoken about the process, and this is where directors are defended by process. And so you need to be thinking in your boards, how do we build a good board process? How do we make sure we put the steps in place? And this is where, as Sadar, we help companies guide their boards through that process and design appropriate decision-making processes in terms of flows of information, flows of reporting, and making sure that we follow those processes consistently. You can't have a process and not apply it, because that's also dangerous in your board around the boardroom table. And so being defended by process is important to think about as we design that. And then lastly, thinking about, we're defended by knowing our position and role. And I think this is where investigating, again, looking at yourself in the mirror, thinking about, how you, what are the key questions you have as a director? Do you understand what it means to apply a set of skills in the boardroom as opposed to just in the operations of a business? Thinking about governing versus managing and the difference between that. And there are lots of books to read. Obviously, that's what we do a lot of training in this space. But it's really thinking through and doing your own self-analysis of what What skills and experience do I bring to the table? And then thinking about the team. So if you're chairing a board, it's a good idea to put together a skills matrix and to think about, well, what are the skill sets in the team? And where do we need to uplift the skill sets so we think as directors and not just as operations or managers or even shareholders in the context of our decision-making process. And so a big topic, but if we want to know what we're doing, it's not just about the specific decision, it's about our role as directors and understanding things like, how does risk work? How does stakeholder engagement work? What is our role in organizational culture? What is our role in holding management accountable? And how do we do that? How does policy work? How does audit work? All of those different things that are questions that one would often have as directors. See some questions coming through, and thanks so much, because I was about to ask for more. Just reading here. So one question here is on, and thanks Rajiv, it's about directors' liability. And so one of the other defense mechanisms, or let's call it remediation mechanisms for directors, is directors and officers insurance. A good directors and officers insurance policy will want to know what you've done in the room to see, have you made a good decision? In other words, process defends whether a decision is good or bad. You see, no directors and officers insurance policy will defend you against the three key things that we've highlighted here: failing in one's duty, abuse, neglect, or dereliction of duty, intentional and gross negligence. So how do you present even to, so something, you make a decision, it goes wrong. What do you present to the insurer to say, actually, we made a good decision? You would show your record of, do we know what we're doing? Did we declare any conflict? Did we make this decision in the best interest of the company? And this is where, again, the insurer doesn't want to second guess your decision. The insurer wants to pay out an insurance, but based on the right thing. In the same way that when you insure your car, you sign certain terms and conditions. When you're signing a directors and officers insurance policy, you're signing certain terms and conditions. And these on the screen in front of you are things they're not going to pay out on the basis of. So you need to show them, and that's even a pre-legal process, you need to show them. And so when I would go to an insurer for directors and officers insurance, I would say to them, what are your expectations on us in terms of process? Does our board process defend our decision-making process and help you as an insurer decide around our claim as well? So I trust that's valuable. Another question here. So yeah, there's a and I'll put it in the chat box. Andre, if you wouldn't mind putting that link into the chat box, thanks very much. It's another avenue to explore, but also a complaint can be lodged with CIPC. If you wouldn't mind putting that in, thanks so much for raising that, because obviously what action can people take? So in South Africa, the action was taken by a group of public organizations, non-profit organizations that took action in the public's best interests. Thanks so much, Andre. For all of you, you can see that's how you lodge your complaint. So what happens in most countries is there's a mechanism created in law that will be a place where you can go as an interested party. That's obviously a critical element as well, to lodge a complaint against directors. And hopefully we've given you some ideas and thoughts in terms of saying, how do you think about this thing called delinquency? Again, revisiting some of these terms: failing, neglecting, derelicting, all of these key elements. These are serious allegations against the director. When someone has been through a legal process and they've been found delinquent as a director, it's not something that is minor, it is something that is serious. We never want to get there. We also don't want our board processes to get to that point in time. So we want to act proactively, and we act proactively, as I said, in three ways. We look at our team. We recognize that we're a team of leaders around the boardroom table because we carry liability both individually and collectively. All right. Secondly, we look at the process we follow. And so we ask ourselves the question in our board process: do we give enough time and attention to the information we get and how we get information and how we examine information? especially if I'm not a specialist in a certain area, I need to know enough to ask the difficult questions. And it's not just about being difficult as a director either, because ultimately we've got to be making decisions, thirdly, in the best interest of the company. And then obviously, declaring conflict and building a process that does knowing, declaration of conflict of interest, and quantifying or elaborating what we believe the best interest of the company to be. And so I encourage you to relook at this, look at yourself first. I really believe that we want to be the ones who are, in a sense, skeptical about our own performance first, before we have someone else who's skeptical about our performance. What we don't want, as I said, is to be the test case of some of these things. In the last couple of minutes, there's a couple. Yeah, so Amit, we'll have to get back to you in terms of the cost, but absolutely, we have board process guidelines. We'll be sending you through some contact details, and we'll get someone to contact you and discuss some of those elements. But absolutely, that's what Sadar does. We don't only train directors, we also help companies appoint directors, and thirdly, we help guide boards going forward. And again, people who need training, please get hold of us. What you will get as a result of registering for this webinar, and thank you for doing that, is you'll get a link to the webinar, but we'll also put some contact details in there, and please visit our website. You can also contact us on the following details. Please engage with us. If there's things that I've unpacked that have triggered alarm bells or some orange lights have gone off, please contact us. We're in the business of helping directors do things effectively. We want to lead to better business, because better business leads to better society, better economies, and that's what our interest is. And so thank you so much for spending the time, taking the time, investing the time. We do appreciate it. Please also share this presentation with other people that you are concerned about. If you're seeing people act in a certain way, rather let them know what's going on than unfortunately being found guilty. I would never ever want anybody to be found guilty of director delinquency, because as I mentioned, it's serious. Have a great Friday afternoon. Have a great weekend. If you're in South Africa, please stay warm, because it's what best we're doing. Until next time, all the best.